I want to thank you for being with us today. Today we have a 2-hour webinar and where we're going to talk about the long-term care discharges under the new assisted living licensure structure. And this is primarily information for residents and consumers to prevent arbitrary discharges. We're thrilled to have providers on this webinar as well. We think that this information, we know it's new and we know that there's a lot of questions around it. And so we're happy to get this information out and have a discussion, really answer questions with as many people as possible. So today's webinar is supported by a grant funding through the Minnesota Board on Aging. And so we want to thank the Minnesota Board on Aging for sponsoring this funding, this webinar. And just a couple of housekeeping things before I introduce the panel and talk about how things are going to flow today. So first, if you have any questions after the webinar, please feel free to check out our website or call our helpline, and our staff would be happy to redirect and to help you through this. If you would like to talk to an advocate about something that you're experiencing or with a client that you're working with, feel free to call us at 651-440-9312. You can also reach us through our website. So happy to have you reach out and talk to an advocate as we work through this. A reminder that we do offer webinars almost every week at this time. Our free webinar schedule gets sent out in an email. So if you're not on our email list, but you're participating today, you will be on our email list now. You can sign up through our website as well. We have several coming up. You can see in front of you on the PowerPoint, so I won't read them all, but we have several coming up through October that are scheduled out, and feel free to, we encourage you to sign up and register for those. So today's webinar is being recorded and all participants are on mute. We really do welcome your participation though. And so in the Q&A box, please feel free to put questions for our speakers in there. We will have a large chunk of time to actually ask questions of our panelists, and I will be monitoring the Q&A box and asking those questions of the panel. So we'll get to as many questions as possible. Feel free to drop them in there at any time. If you have other comments for us or for each other, feel free to use the chat box. But if you can put your questions in the Q&A box, it will be easier for us to make sure that we're getting to them. And then we do have auto-generated captioning, and you can look under live transcript and get the captions as well. So we will, after the webinar, email out a copy of the slides today and the presentation. A recording will be available if you want the copy of the recording. CEU, certificate of attendance, will be emailed to all attendees as well. We also will be asking for an evaluation and some feedback through a survey. Please do fill that out. It helps us improve the future webinars and make sure that we're able to sort of meet your needs as participants in this. So I want to first, before we get to the panel part of our presentation, we have Sean Burke with us. Sean is a consultant for the Minnesota Elder Justice Center and works for O'Connell Consulting. Sean's been working on our behalf on the assisted living licensure, along with many others for the past couple of years. And so Sean is here today to provide about a 20-minute overview of how we got to where we are and some stage setting. And then we will have a panel of experts available to answer both Sean's questions and your questions as well. So we will have time for questions about this. So with that, I am going to introduce Sean Burke and have you take it from here.
Great, thanks, Amanda. Just checking that my slides are up and you can hear me okay?
Slides are up and we can hear you.
Great. All right, so as Amanda said, we have a really full agenda today, and glad that everyone can join us and that the response was so great. I'm very excited to talk about our panelists here in a little bit, but before we kind of really dive in to the nitty-gritty, we thought it would be important to at least do an overview. So we have kind of a baseline understanding of the real basics of what we're talking about. And then through the discussion and our panel discussion that I'll help facilitate with our panelists, we can really dive deeper into each of these topics. So this is what we're going to do. I'm going to go through kind of a quick overview. To spend no more than 20 minutes, and then we'll spend a bulk of our time in our panel discussion, and then we'll have time for questions, as Amanda said. So before I dive into some basics about what the new assisted living law does in terms of providing protections and rights for residents in assisted living, I want to just take one slide to set the context and remind us about kind of where we came from and really why we are here today covering this specific topic. So several years ago, 5 years ago now, starting around 2016 and going through the 2018 legislative session, there were a variety of legislative proposals around strengthening rights for residents in long-term care. During that time, it was the winter of 2017, there was a large expose in the Star Tribune about abuse and neglect in various long-term care facilities, including nursing homes, and at that time, what we called housing with services settings and other facilities as well. So there was a large outcry from the legislature and from the public to do something. In the 2019 legislative session, that is when the big bill that is really the subject of what we're talking about today was passed. It was known as the Elder Care and Vulnerable Adult Protection Act, and it did several things. It created several rights and protections for residents in long-term care settings. But the bulk of what it did was create a new assisted living licensure system. And it didn't do that right away. It basically set a 2-year time frame for the Minnesota Department of Health to put together and implement this new system. And it was to start on August 1st, 2021, which you'll see there from the last slide, it did. And so what we're dealing with now is a system that is different from what we had for several decades. So of course we have in our long-term care continuum, we have nursing homes, skilled nursing facilities. Those are kind of at one end of the spectrum. And then in terms of services and care level of needs. And then at the other end, you would think about completely independent living on the other end of the spectrum. And then in Minnesota, we had what was known as housing with services, which kind of made up a variety of types of settings in the middle. And there were several issues with housing with services, and these are things that came out during those legislative sessions that I alluded to. There were always 2 contracts with 2 different providers, usually 2 different providers, which made it really confusing for consumers. It also really made it confusing for the regulators. And as part of those legislative sessions, and also as part of the Star Tribune series I mentioned, it also came to light that MDH as a regulator was having issues regulating settings and also internally with doing what it needed to do to actually protect residents, especially when there are claims of maltreatment. So the confusion around housing with services, the confusion around how to regulate these settings was a huge part of bringing everything together under one license. For today's purposes, what's really important to know is in the old system, essentially regular landlord-tenant applied, and so so that meant there weren't appeal rights, as you will find out residents have today, to the Office of Administrative Hearings in front of an ALJ. And a landlord or an assisted living provider essentially could, or housing with services provider, could evict a resident for any non-discriminatory reason, as long as it kind of fell under that purview of landlord-tenant law. And as you'll see today, that's a lot different than the current system that is now in place as of August 1st, which looks a lot more like our nursing home system, which is a nationwide standard. And in the old system, there were also very minimal requirements for providers to assist with the actual discharge process, so that if someone's actually going to have to move, there wasn't a lot that a provider needed to do to help facilitate that. That has also changed, and you'll see that in detail as we move on today. So that's kind of a really quick snapshot of where we came from and where we are. So I'm going to switch bases just a little bit and spend the rest of these opening remarks talking about these specific new discharge protections that exist under the new assisted living law. So just again, where we're coming from, if you are providing assisted living services, essentially used to be called housing services, you now have to get a assisted living licensure. Those providers who are on this webinar know that and have gone through that process with the Department of Health, or if you're not yet up and running, you will be going through that process. As part of that license, you have all sorts of requirements. And many of them, the ones we're going to talk about today, deal with how to discharge a resident legally and what protections the resident has during a discharge process. So what this slide does is kind of highlight what I kind of think of as the five big buckets of or stages of a discharge. And this is what we're going to spend a lot of our time in the discussion with the panel afterwards talking about. You'll notice the first one listed is actually a meeting that has to happen before an actual notice of termination goes out. The facility has to help facilitate a pre-termination meeting. We'll talk about what's required there. There also must be a statutory reason for the discharge. This particular change to the law might be what's most different from the old system to the new system. Under the landlord-tenant law in that last slide, if you have a non-discriminatory reason to evict someone, then you can do it. But under nursing home regulations, and now under this assisted living statute and rules, a facility actually can only evict someone or end their services, discharge someone, terminate someone for certain sets of reasons. And we're going to go through what those reasons are. As I mentioned earlier, a resident does have appeal rights now under the new system, and they don't appeal to a housing court or a district court. They appeal to an administrative law judge at the Office of Administrative Hearings. We'll talk about that process a little bit today. As the process is going forward and the discharge process is proceeding, even before an appeal happens, there's a lot of requirements that a facility has to do to help with what's called a coordinated move. And that term coordinated move is actually in the statute. That's the term that's used. So it's helpful to start getting familiar with that language because those are all the requirements that a facility needs to help a resident with. And it includes finding a suitable setting and helping with the discharge. And we'll, again, go through those more in depth. And then there's another kind of bucket of other rights and other requirements that exist that relate to discharge in some ways. So you'll see those listed there, the right to return from a hospital and the rights when a facility chooses not to renew a contract, not necessarily to discharge someone, but to not renew a contract. As Amanda mentioned, these slides will go out, so you'll have this as a reference. This is not an exhaustive list, but for those of you who like to dig into the statutes and the administrative rules, whether you're an attorney or not, these are the helpful references you'll find to get you started on where these laws actually exist. So the new assisted living law is 144G, and 144G.52 and .54 would be the most relevant for most of what we're talking about today, although there are other provisions listed below. And then for those of you familiar in this space, it's not just a statute that governs the law, but as part of the 2019 law that I mentioned earlier, the Minnesota Department of Health went through a rulemaking process and developed administrative rules that apply to the entire assisted living licensure system. And the ones that are most relevant, again, for discharge and appeals are listed below. So it's not just the statute, it's also the Minnesota administrative rules that you'll want to consider as well. So I'm going to wrap up by talking just a little bit more about each of those buckets, and then we will get started with our facilitated discussion. So I mentioned pre-termination meeting. This is actually the beginning of a discharge. If a facility wants to discharge someone from an assisted living facility, they first have to schedule and participate in a pre-termination meeting. And that means in that meeting, they have to identify the reason for the discharge and alternatives to the discharge. The meeting has to be scheduled at a certain time. And then after the meeting, the facility needs to provide a written summary of that meeting, so it's really clear and everyone understands what was talked about and what was discussed. We'll talk about this in depth, but one of the real purposes here is to try to find a resolution to the underlying issues that are even leading to the discharge. And I think hopefully whether you're a provider or you're an advocate representing a resident in one of these issues, the pre-termination meeting is really designed to be a forum where if there's a resolution to be had, let's have it without having to necessarily go through the entirety of an appeal. Although of course that might still be necessary. So that was bucket one, pre-termination meeting. If the termination proceeds, the provider needs to issue a notice. And as I mentioned earlier, they need to follow the statutory prescribed reasons for discharge. You have to have a reason, and the notice has to describe in detail what that reason is and the specifics behind that reason. So you'll see the list articulated here. The statute goes into a little bit more detail. These are basically summary headings and the reasons that someone could be discharged. So everything from a failure to pay to the last one, if there's extraordinary circumstances that exist where they can't provide the services anymore, they may terminate services. So again, we'll go through these in more depth in a bit, but just a reminder, and it's really important, whether no matter what side of the discharge that you are on, resident or provider, that you know that there are statutorily prescribed reasons for the discharge. So let's say the appeal, or let's say the process continues, there's no resolution, the notice has been given. In that notice, a resident will also receive their appeal rights. And as I've mentioned a couple of times, this is a big change from our previous housing with services system. That resident can appeal the discharge just like if they were living in a nursing home, and their appeal will be heard by an ALJ in the forum of the Office of Administrative Appeals. That ALJ will then listen to the appeal, listen to both sides, and make a decision and issue a decision. There are also appeal rights after that appeal that are a little bit beyond the scope of today's session, but happy to talk about those a little bit if folks have questions. You'll also notice, and this is relevant for today's discussion, because we have two representatives from the Office of Ombudsman's Office for Long-Term Care, that the discharge notice that someone receives is actually sent to their office right away, so they understand and know kind of all folks throughout Minnesota who might be in the process and can help. So not the first time I'm going to flag that, but if you are a resident or a resident advocate, you're working with the resident, be sure to reach out to their office. They will talk a lot more about the services they offer as we go on in our discussion. Also, it's important to know that the resident has the right to remain in the facility during an appeal. That doesn't necessarily mean that they have the right to receive free services from a facility. And I know sometimes that can be a question. We can talk about that a little bit more, but they do have the right to remain there as the appeal is ongoing. Here is the timeline for the appeal. We're going to come back to this in one of our questions, but just a couple of quick highlights. After that pre-termination meeting, the resident will receive a discharge notice. And then they have a certain amount of time to actually send the appeal into the Office of Administrative Hearings. And that timeline depends on what type of discharge is happening. Is it because it's a failure to pay, which is a 30-day appeal, or is it because the facility can no longer meet their needs? And that's a 15-day expedited appeal. Then the OAH needs to hear the appeal within 14 days. And then a decision is given no longer than 10 days after that. So you'll see kind of the lifespan of what an appeal would look like from both the provider and the resident perspective. Just a couple more concepts around appealing a discharge. The forum at the OAH is designed to be flexible. Attorneys practice there, attorneys for residents, attorneys for facilities as well, but they don't have to, and others can advocate as well, and individuals can certainly represent themselves. I think most of us on the advocacy side would strongly recommend that residents facing a discharge at the very least contact the ombudsman's office, but really seek legal help as well if they want to go through an appeal, because there are a lot of legal complexities that even well-seasoned advocates might not be able to tease out in the course of a discharge. I've already mentioned that the appeals are decided by an administrative law judge, and the process provides the forum. So just a little bit more about what I mean by that. If a facility is claiming in the discharge notice, first in the pre-termination meeting, and then in the discharge notice, that we can no longer meet your needs, we're going to be terminating your services, the individual disagrees with that, says, no, I think you can meet my needs. You've been doing it since X, Y, and Z, and nothing's really changed. The facility then has the burden to bring the evidence to say, no, judge, we can't. This is why we issued the notice. We can no longer meet their needs. Here's our evidence. Please rule in our favor. And then the resident will say, no, they haven't proven their case. They can still meet my needs. Here's my evidence. Please rule in my favor. So that's what we mean by this forum. So it's still very much a legal process, even though it's not going directly to a court of law. But again, it's that balance between attorneys can advocate, but non-attorneys can advocate as well. And then a couple of those other buckets that I mentioned that deal with discharge. So there is, it's not infrequent for a resident of an assisted living facility to need to go to the hospital or to be sent for the hospital for acute medical issues or even longer term medical issues. Under the statute, if the resident is relocated by the facility for medical or other reasons, they do have the right to return to the facility. And if the facility is essentially saying, this is the assisted living facility, hey, you sent to the hospital, we've been talking to the hospital, it looks like your needs have changed, we can no longer meet your needs, you can't come back here. That actually is not how this statute works. So if a facility believes that they can no longer meet a resident's needs and that resident is in the hospital, they still have a right to return, and the facility needs to go through the process we just talked about. Whereas they need to do a termination meeting, issue the notice, provide the reason, there's a right to appeal as well. So I know Maisie, one of our panelists, might talk about this a little bit more, but it is not legal, essentially, under the new statute for a facility to say, sorry, you're in the hospital, we can no longer meet your needs, take care, bye, contract's over. That contract would have to be ended through the discharge process and all of the protections we've talked about up to this point. If a resident is going to move, needs to move, maybe they've lost on the appeal and the ALJ says, yes, I agree that the facility proves that they can no longer meet the needs. The resident does need to move. That's not the end of the story in terms of the facility's responsibility. So as I mentioned earlier, this term is something to get used to in the language. A coordinated move is something that the facility needs to do in order to effectuate all of their requirements under the assisted living licensure law. So they have to do a detailed discharge plan. There has to be specific details about the transition. The new setting has to be suitable. And there are some specific things in the statute cited as not suitable. So say a homeless shelter or a place where there's no services set up, i.e. sending someone back home without any home and community-based services set up for them there. And then that, so not only does it have to be suitable, but it also has to be safe as well. And so there is a lot of work that an assisted living facility needs to do to participate in this process. I will note that this is similar to the requirements of a nursing home for those facilities and those who work in facilities that are familiar with those requirements. there's a lot of similarities. And just a few other rights that are, I think, not directly related to discharge, but important to remember that are part of that 2019 law and part of the assisted living licensure requirements is that an individual has the right to place an electronic monitoring device in their room, subject to requirements about how to do that under the statute. That in the past has been a point of contention and even a point of potential discharge. And so an individual has that right now, and that should be considered as part of kind of the bucket of rights in there as being a resident. They also have the right to be free from retaliation, and oftentimes I'd say the turning point of retaliation would be a discharge. I think the Ombudsman's office, both Aisha and Maisie can speak to this quite a bit, but they've talked with individuals who are being ultimately discharged, and they believe it's really related to retaliation for, say, advocating for their rights in other areas. And so that can be an issue that comes up potentially in the context of a discharge. An individual has a right to participate in their care planning process, and they have a right to ask for reasonable changes in policies and rules to accommodate their needs and preferences. Both of these last two might be relevant in the context of a pre-termination meeting, where in order to resolve the underlying dispute, an individual is simply asking for a facility to make some changes to their policies, which is both their right under the statute, but would also be a way to avoid a discharge. We're going to, like I said, make these slides available. So there's several resources here in purple. I will note, and I'm sure we'll bring up again, the Office of Ombudsman is a big part of our long-term care system, and they are mentioned many times in the new statute and in the discharge process. I already mentioned that they are supposed to receive a copy of any notice for discharge. They're also supposed to receive other notices as well. So if you are a representative of a facility or work at a facility, it would be very important to make sure that you're familiar with that notice form, that second little bullet there, and we'll send that around again, so that you are meeting all of your requirements under the statute to provide the correct notice to the Ombudsman. So with that, we are going to transition over to our panel discussion. And let me stop sharing for now.
Great, and I'll introduce the panelists while we're getting them set up and on. So we are thrilled to have staff from both the Minnesota Elder Justice Center and our partners at the Ombudsman, Office for Ombudsman for Long-Term Care with us today. And so we have Maisie Blaine with us. Maisie's a licensed social worker with the Office for Ombudsman for Long-Term Care, and she's been with the office for about 9 years. She serves currently as the lead statewide policy advisor in helping interpret the rules and the statutes and the policy related to long-term care. And she holds both a master's degree and a bachelor's degree in social work. And she spent many years as what we call a frontline ombudsman as well. So welcoming Maisie. We also have Aisha Elmquist, who's an attorney and with the Office for Ombudsman of Long-Term Care. And she serves currently as the deputy ombudsman at the office. Before working with the ombudsman, Aisha was an attorney with the Legal Aid Society of Minneapolis, and also with several private law firms. She holds a BA from Carleton and her JD from the University of Michigan Law School. And I know worked also on the 2019 legislation and the rules as well. And we also have Betsy, our victim services manager at the Minnesota Elder Justice Center. Betsy's been with our office since March of 2020, has been working in providing client-centered care, victim services advocacy work for the past 10 plus years, and really takes a victim-centered, person-centered approach to working with victims and clients. And Betsy has a Bachelor of Science in Psychology from Bethel, and focuses on a lot of self-care for herself and others, and will remind us of that today as well in terms of how we work with individuals in crisis. So The next about hour of our presentation will actually be a facilitated discussion between Sean and our panel, and we'll answer many of the questions that I know come up with this, have come up or are coming up with this new law. And then the last about half an hour, I'm seeing your questions in the Q&A, and we will move to answering some of those. And so if we don't get to those questions in the webinar format, we will try and answer them directly through the Q&A. We're going to try and get to as many as we can in this the session here today, and I may pop in and interrupt as well if there's a question that's relevant to something that Sean is asking or the panel is discussing. So Sean, I will turn it over to you.
Okay, great. And I'm going to turn it over to our panelists because I've already been talking a little too much, because the first question will be the easiest. Amanda did your kind of formal introductions and bio, but I would love to go to each of you just real quick and talk about how you personally in your job interact with this discharge process, whether it's with residents or family members, and generally kind of the perspective that you're going to be coming from and sharing your ideas with us today. And then we'll dive into the actual topics after that. So Maisie, can we start with you?
Sounds good. Thanks, Sean. So in my role as a policy specialist with the office, I work closely with the regional ombudsman staff to ensure that these new protections are followed and honored as they advocate for residents. Previous to my work in policy, I did this. I was out kind of on the front lines advocating for people, ensuring the previous protections in place were honored. And we, you know, as the assisted living law came to form and all the collaborative partners that went into that, you know, came to the table. The things that we've done, the advocacy that we've done behind the scenes for years really helped inform that law greatly and added a lot of these really great protections that we see in the law today. So I'll pass the torch maybe to Betsy.
Thank you. So yes, my name is Betsy. I am one of the advocates that answers the helpline regularly, and we function at the helpline level as a support to whomever the caller is. We take a lot of calls from victims themselves, older adults or vulnerable adults, their supportive loved ones. So it might be family, friends, neighbors that are concerned. We've talked with ombudsmen. We've talked with facility care providers. So we're really here to just keep the communication flowing well, to help people understand systems, to provide empathetic listening in these very sometimes stressful situations. We're safe, we're confidential, we're free, we are not mandated reporters. So it truly is a place where people can process out loud and know that they will be heard, they will be understood, we can validate their experience, and then try to help them find those resources and referrals and that empowerment to make the next healthy steps with whatever decision making they're needing to face. So that's my role. I will pass it to Isha.
Thanks, Betsy. So my role in the office is I supervise about half of the team at OOLTC. We call the Office of Ombudsman for Long-Term Care. And a lot of those folks are regional ombudsmen who are around the state every day representing people in nursing homes, assisted livings. And those are our two primary areas of focus in terms of the clients who are calling us, but we also do work for other people receiving long-term care services in the community, such as people receiving home care in their own homes. And we also do work in HUD exempt settings, which are settings that are exempt from assisted living licensure, but are providing assisted living services. So we provide that direct advocacy going into the facilities on an almost daily basis, also providing services over the phone on a wide variety of resident rights issues. So with that, I'll pass it back to you, Sean.
Great, thank you. And I will circle back at the end to talk, put another plug in for the services that both the offices, NEJC and the Ombudsman's Office provide. So let's dig in. The way I want to start is I want to kind of do the same flow that I just presented in terms of kind of the lifeline or the timeline of an appeal. or a discharge. So let's go to that pre-termination meeting. Let's start with that. And Aisha, the first question is for you. Can you talk a little bit more about really what is the purpose of this pre-termination meeting? I alluded to it a little bit, but why is it in there? From both a provider's perspective and a resident's perspective, what should they be thinking about and trying to get out of it if there's a good faith effort to actually engage in what the statute requires?
Absolutely. Thank you. That's a great question. And our office, terminations has been one of our top complaints for years. So we have a lot of experience in this area. And we know that in many circumstances, really the goal of everyone is to avoid termination. And so the hope is that this meeting would serve as a place where solutions could be explored. And it may be that at the beginning of the meeting, one or both parties is thinking that's not possible. But how can we come to the table and have creative solutions? And part of what's really important for the pre-termination meeting as well is the written notice that is required in advance of that, which will tell the resident a little bit about what their protections are. For example, telling them that if this meeting does not come up with some sort of resolution or solution, that they have the right to appeal, but also who they might invite to the meeting. And there's a list of people that the resident is required to be notified that they could invite. And one of those entities is our office. And I can say that we are already starting to receive some calls from people who are getting that information, who are following up with that. We've had some regional ombudsmen who've attended these meetings and are really working to come up with those person-centered solutions. Another requirement for these meetings is discussion of reasonable accommodations and the requirement that there's really an interactive process. So the resident and their advocates, of course, should be thinking about some potential reasonable accommodations, but also that the provider has the obligation to do that as well and to offer any reasonable accommodations that it may be aware of that would help to resolve the underlying issue. So those are just, I guess, kind of a high-level summary of what the purpose of the meeting is. And there are some other protections around the meeting that are very important to residents as well.
Thanks, that's helpful. And when you're engaging in that, if you're engaging in that process, we would recommend familiarizing yourself with all those requirements, both in the statute and the rule. Betsy, you mentioned earlier you talk with anyone in the process. You get a lot of calls from family members. They call you and they say, "Hey, we're going to this pre-termination meeting. Should I go to it? What's the value in this?" What's your response to them? In kind of hearing a little bit what Aisha said, but also kind of counseling folks who are scared because they just got this notice and they don't know what's going on. And there's probably been some underlying issues with the facility up until this point as well. So what are you generally advising at this point?
So I really appreciate this part of the statute change, because this is exactly what we encourage people to do, is to have clear communication. And this is one of those places where everybody will sit down at the same table at the same time to get the same information. So even though in these stressful situations, avoidance is kind of a default that a lot of people go to, trying to really engage this process, the way that the format goes, the way that the process goes has slowed it down so that there is time for answering questions, for exploring safety concerns, for mapping out new creative solutions. So the more involved we encourage people to get in these processes, the better the communication is with everyone involved, the more informed they can be right away up front. And it clearly helps delineate the roles that each person at the table is there for also. So we strongly encourage people to participate. And the note taking at the end of the meeting too is really helpful to have kind of a summary of what's been decided, what was discussed, so that information can be dispersed if it needs to be to a broader family system.
And one more on this, Maisie, we're spending some time on this, I think, because it is new and it's not unique to the law per se. There's other places where this happens, but it is probably new. It's going to be new to a lot of providers. Aisha, and residents as well. Maisie, obviously we've talked about some of the benefits of this, but there could be some drawbacks too. And I know that your office also gets a lot of complaints about retaliation and fears of retaliation. And so a hesitancy to kind of go into a meeting and be, admitting things or just being, having a conversation where yet once again they might be retaliated against is probably a reality for a lot of folks. So what are some drawbacks and what are some other maybe not necessarily cautions, but just to be aware of, especially if the pre-termination meeting doesn't resolve the issues?
Yeah, thank you, Sean. I think definitely attending the meeting is in the benefit of the resident and or their, representatives. I think though, having some support at that meeting, whether that be through a family member, whether that be through an advocate, whether with our office or somewhere else, maybe a case manager, having someone there that can maybe mediate or de-escalate the situation if it does become heated. I think sometimes there are communication barriers and, facilities. I think the important thing to know here is no facility ever wants to kick someone out, right? They went into this business wanting to serve and care for people. And so there just end up being really complicated situations sometimes that arise where they feel they can no longer do that. And so sometimes that's a safety issue for the resident. Sometimes that's conflictual relationships with family members. Sometimes it's financial in that the resident maybe isn't paying for their stay. And so I think the meeting gives an opportunity to kind of sift through those things, having a definitive reason for the termination ahead of time so that they can say, oh gosh, wait a minute. They were serious about the non-payment, right? I've been getting all these bills and I'm kind of overwhelmed and I didn't really know what to do. And now they're saying they legitimately can kick me out for that. And so, maybe that entices them to call a support person or reach out for assistance and we can work to get those things resolved. So even if the pre-termination meeting could potentially get heated or have some kind of conflictual communication, it's a good opportunity to really fully understand the points of view of every person in attendance.
Happy to come back to the pre-termination meeting with other questions. Just a couple of final thoughts as we wrap up on this. Just to note that there are requirements that the provider has around the meeting. They can't force someone to show up, but they have to help facilitate it and participate in it. And remember that also, this could really ultimately resolve the hearing and resolve the need for a hearing. Although it doesn't have to, the conversation doesn't have to end after the pre-termination meeting. You could continue to have kind of what we would say in legal circles as settlement discussions, even leading up to the hearing as well. This could be a launching off point. So thanks for those thoughts on the pre-termination. Let's move down the road of an appeal. Let's say it didn't resolve everything, and an individual gets a discharge notice, and it has as a reason for discharge that the facility can no longer meet their needs. You all can weigh in on your thoughts. I suspect this will be a pretty common reason for needing to discharge someone. As Maisie said, I think at least my personal experience is a lot of providers do want to serve folks and they want to do their best, and they truly believe that they can no longer in some circumstances. But in other cases, that's a disputed issue. And you may think to yourself, wait a second, how is it a disputed issue that we can no longer meet your needs? We said we can no longer meet your needs. But as an example, what if a dementia care resident has been wandering quite a bit, wandering maybe more than any other resident, and it's taking a lot of staff time and it's difficult to deal with, and ultimately the provider issues the discharge. You've gone through the pre-termination meeting. The reason is because we can no longer meet your needs related to your wandering behavior. So Aisha, I want to turn to you again. So first of all, would this be kind of a legitimate thing that you might counsel a resident to or their family member to consider appealing? And talk to us a little bit about this appeal. It's kind of tough, right? The facility says we don't have the staff to care for your wandering anymore, but you as the resident, or at least the family, is like, hey, 6 months ago we came into this place thinking we'd be here for the rest of mom or dad's life. And now they're saying we have to go. Can we appeal this? We know we can. Should we? And what should we really be looking at if we want to win the appeal or potentially want to settle something out? Can you talk a little bit about this situation?
Absolutely. So if we as the Ombudsman's office were involved in the case, one thing that's very important to know about our office is that we are advocates directly for the resident. So no matter, we can take complaints from anyone, be it a family member, a provider, a social worker, but ultimately we get that direction from the resident if the resident is capable of giving us that direction. So we would go and meet with the resident and talk to them about what's happening. If we ultimately hear from the resident that they no longer want to live there, then that is the direction we would take. But we would make sure that they know their rights. And one of their rights, as you said, Sean, is to appeal. Now, whether that appeal is advisable would be very fact dependent. And I can talk about some of the things that we would look at in making that determination and advising the client. There certainly would be circumstances, and we've handled them and we've successfully handled them in situations, including people with dementia who are told a facility can no longer meet your needs due to dementia. That's not just a black and white situation. We'd really have to look more into the details of that situation. So some of the things that we would be looking at is what type of license does this facility hold? Is it assisted living licensed or assisted living licensed with dementia care? Either place can care for people with dementia. But the reason that we would look at that is to see what are the minimum requirements applicable to this facility? And that varies a little bit depending on what type of license that they have. And is the facility doing the things that are required in those minimum requirements? As an example, are there activities that are being planned for the resident? What types of assessments are being done for the resident? Is it possible that if a facility was better complying with these underlying requirements that apply to all facilities with that license type, that the issue that's arising, kind of like what's the root cause or one of the root causes of what's occurring here, could that be resolved? Looking at also the disclosures of the facility, what's in the contract, promises that have been made, care they're providing for other individuals in the same facility to the extent that we may know that, physical plant issues related to the facility, all of that would be relevant to what we would be looking at. And we'd also be looking very seriously at reasonable accommodation requests that we might be able to make, or those that could also sort of be framed as ways to cure under the statute the issue that's going on. And some of that could involve a wide variety of scenarios. And I'm sure Macy has about 100 different examples she could give of the types of creative solutions that can potentially be used. But certainly if the resident still expressed a desire to live there, or there was really no other place they immediately knew that they were able to go, even if eventually they might be willing to go, we would advise making sure to meet that appeal timeline of the 15 days to file that appeal and to work to build their case and move forward with the appeal.
We do have some questions about that in the Q&A that I think this is a good place to address them. So what if a resident, wins an appeal on a discharge, say the facility could no longer meet their needs? If a resident wins that appeal, what can you do? What can the facility do to try and meet needs that they feel they can not meet?
So my perspective on that is, again, that it's going to be so fact dependent in terms of what those specific solutions might look like. But if the ALJ has reached that determination, then the determination is that the facility should be able to meet those needs. So the facility should be looking at how is it going to do that, and having those collaborative conversations with the resident, with the regional ombudsman if they're involved, with other support persons, to figure out how to make it a safe environment for that individual. I don't know, Macy, if you wanted to add anything to that, or Betsy.
Yeah, I think if we're getting to the point where, if we've gotten to the point where the appeal has successfully resulted in the resident getting to stay, having, again, if our office is involved, having a conversation with the resident, with their support persons in their life in their lives that they've identified with the facility. Let's say this is the example we just used. This is a assisted living facility without dementia care, right? And this was an example where maybe somebody was seeking elopement but hadn't successfully eloped, right? That might be a reason a resident would prevail in an appeal. They had sought to get out of the facility, but each time the staff had redirected the person back inside and was able to de-escalate the situation, and it resulted in safety. So the care and service plan requirements that were in place are being met. I think building on that to say, okay, what is it facility that you feel still is a risk factor, right? Making sure that that's identified in an abuse prevention plan, making sure that that's identified in a resident service plan, pulling in other support persons, family members. Is there behavior that coincides with after a certain program is watched on TV, or after a certain visit occurs, or after a certain phone call, or after a certain meal has had. I mean, we've kind of heard lots of different examples. So really, I think Aisha talked about root cause and really doing that root cause analysis, what is precipitating what is happening. And then there, I think, are other more complicated examples. So perhaps I do think I saw in the Q&A, what if your facility says in their UDALSA that we don't offer two to transfer, right? We only offer a single one assist transfer, and for whatever reason, this person has had a decline in their physical status, and now they need two people. What kind of conversation can we have about what are supplemental services that could be brought in? Are there family services? Are there kinship or friend services? Are there outside agencies that could come in and supplement those services? Are they only needed during a certain period of time? Was this an isolated incident, or is it happening daily? So really taking a look, peeling back the layers, and looking at all of those things that Aisha talked about: the physical plant, the person's needs, who they have for support systems, the services that the facility offers. These, we don't get called on easy things, right? I mean, if they were easy, the facility resolves them themselves, the family resolves them, the resident resolves them. This is, we kind of live in the gray area of the world, no pun intended. And it really is complicated, and each individual case has to be assessed that way.
Any others, Amanda?
Yes, we have many, but I want to be able to, some I think will be worked in. There's
Okay.
another question around that kind of fits in with this, and there's been a couple of them, but what about returning, say, from a hospital stay? So we've had a couple of different questions about that. Maisie, you just sort of touched on one. What if someone's needs are now different than what the hospital might require? Do they have to take somebody back? And then
Yeah.
And then the other question that we got: what if the needs are so different that they can't return back to an assisted living and might need nursing home care, but the person's refusing that? How do you work with, or what can a provider do, or family members, advocates do to assist?
Yeah, and I can start, and then other people can chime in. This happens a lot, right? Someone goes to the hospital, they've had a medical emergency, their physical needs have increased, and perhaps a doctor recommends, a short stay at a skilled nursing facility, and the person says, absolutely not. I won't do that. I'm going home. That's that. And so I think really, it's no different than if I go to the doctor and I step on the scale and that number is a little higher than the doctor would like to see, right? And they say, hey, look, you need to really lay off the sweets and the sugar. And when I leave, I may or may not pull through the Dairy Queen drive-through, right? I mean, we still get to make those choices. In this case, I think what really needs to happen is that a facility needs to follow what's delineated in the statute. So an appropriate assessment, right? They're going to contact the facility, the hospital. What are those needs? Is it to transfer? Is it only to transfer when the person's tired at night? Is it a temporary to transfer because they've been in the hospital for 14 days and they've gotten weak? Can we bring in a Medicare certified provider to do some temporary therapy services or get them assessed for that eligibility? Can we bring in an outside agency or have family come in and supplement care for a period of time until they rebuild that strength? What specifically does that look like? So I think, again, this is going to really be individualized, but these are really hard because, you know, providers don't want someone to come back and be injured and you know, be hurt under their care and under that umbrella. And so you do have a responsibility to really assess what their needs are and then work collaboratively with the person, with the hospital, with the family members to see how can those needs be supplemented. Because just because that MD says that person needs skilled care or any higher level of care doesn't negate their right to due process, right? And so that's the challenge, is we just have to make sure that we pull those pieces together. And maybe that means having a virtual care conference while the person's at the hospital. Maybe that means having that pre-termination meeting while the person's at the hospital, or you've given some sort of a notice, an expedited notice. So there are a lot of scenarios that could occur here, but really, again, peeling back the layers. What are the needs? How could they be met? Because maybe the person says, you know what, you're right. I don't want to go to the skilled nursing facility, and I know I might need more care than you can provide, but this is really the place I identified if I ever had to move here, and they don't have any beds for 3 months, right? Or whatever that timeline is. Maybe you build in a temporary plan with those outside providers or family members or whatever that looks like for a period of time. So there's a lot of compromises that can be made here. And really, again, just peeling back the layers. I'll let someone else who has some input go ahead.
No, I think that's really helpful. I think what it highlights, I mean, we started this question off about a resident appealing a case where they can't meet their needs, and it's very clearly not an open shut thing. And if anything, this appeals process should provide the forum and the circumstance to have these tough discussions. Two other just real quick reminders in this space. If an individual is sent to the hospital and they want to return, but the provider really feels like they cannot meet their needs anymore, they need to still go through that entire process that we're talking about, because the individual does have the right to return. So let's, and also, and maybe Aisha, just weigh in real quick. If that individual does return, the provider says, we can't meet your needs anymore, there might be a question about who needs to pay for that additional service, say that additional transfer service. And the statute doesn't necessarily require, say for the example that Maisie just brought out, where you maybe need some temporary 2-to-1 when you've never needed that before, doesn't necessarily require the facility that's serving the individual to pay for that. Maybe that has to be a part of the resident's responsibility, but it's not a reason to discharge them or not let them come back.
Exactly. Thanks, Sean. And if it's something that, you know, if it's a service that already should be provided under the service plan, then that's one thing. But if it's truly an additional service, the statute is explicit that the resident does need to pay for it. And the rules also state that there's an obligation of the provider to inform the resident of the responsibility to contract for those additional services and pay for those additional services.
And I would just jump in on that too, when we're talking about consumers who maybe receive waiver support under Medicaid to pay for their stay. There might be a place where, you know, that requires some coordination, right? Maybe the hospital, maybe the assisted living facilities getting in touch with that case manager and saying, hey, you know what, this person has had a significant change in need and we really need a new assessment, because perhaps those waiver dollars could be bumped up to offset, you know, the facility's inability to provide that care. And so, you know, those are just other pieces of this if a person is not privately paying.
There are just a couple other questions in here around, and then I'll let Sean move along, but around really getting at kind of some liability and discharge planning. You know, if there's one that is, wouldn't the hospital be guilty of inappropriate discharge planning if they're sending a patient back to AL when AL is or states they are unable to provide for the needed level of care? That's kind of one question. And another one that's semi-related is really around, so let's say an individual wins an appeals process and gets to remain in a facility. If the facility has stated they can't provide their needs, meet their needs, what happens if something bad happens because they couldn't meet their needs? Who is liable? So a couple different questions, but both really getting at what happens when an assisted living says we can't do this and somebody else says yes you can and they cannot. How do you work through those? Is it really a case-by-case situation on trying to determine if that assisted living can?
I'll just speak to this briefly, and I'm sure others have an opinion as well, but I would say it really is a case-by-case basis. So there's a difference. It would be really unfair to an assisted living for any MD at a hospital to just blanketly state that an assisted living can't meet the needs of a person, because for anyone who runs an assisted living or operates an assisted living or works in an assisted living or visits lots of assisted living, they're all different, right? They all provide different care needs. Some are just an independent apartment and you cook for yourself and you clean for yourself, and maybe they come and put your TED Talks on once a day, and others are providing really high level of care and services. So I do think it's very individualized. Again, as advocates, we aren't the person at the assisted living facility who's saying what you can or cannot do. What we want to assure is that a person has the right to due process. And so, for example, if a person is now a 2 to transfer and you don't have a mechanism at night for there to be 2 people on staff, you have disclosed in your UDALSA that you only have 1 person on staff, you only accept people for admission that require 1 person assistance, you have stated in your UDALSA, it's a limitation of service for you to assist with 2 people. That doesn't mean that the person isn't entitled to come back. It means you can't provide that 2-person assist, right? You've disclosed that. So is that 2-person assist going to come from another source? Is a family member going to come in the 4 times a day that the person, goes to the bathroom? Is that really reasonable? Does the person have a scheduled trip to the bathroom, or do they need more support than that, kind of on a PRN basis? So I think really peeling back the layers, and nothing is to say that you couldn't do an expedited termination of services and say, hey, we fundamentally can't meet the needs of this person, but that doesn't necessarily have to terminate the housing, right? And then they could bring in alternative services. Now, whether or not your contract says they have to pay for both sets of services is up to you, but you can say we can't serve them because this is dangerous. The example that I like to give that's really cut and dry is ventilator care, right? You go to the hospital and all of a sudden you are placed on a ventilator and you're stable and ready for discharge, but you're still on a ventilator. You're not likely to go back and receive services from the assisted living that you were serving. They might not have an RN around the clock. They haven't trained their staff on the use of ventilators. They don't have the proper mechanism in place. They can't hire enough RNs to come in and run it around the clock. So what does that look like? Do you have a family member come in and they're trained by a home care agency to operate your ventilator? Do you have an outside provider come in? So I don't think at any point, as advocates, we would be saying you must do this, but you have to assess, and then you have to follow the process outlined in the statute and the rules.
One more question that touches on something that you just said. So great, you could still live, an individual could still live there. We can't meet the needs for services. We have to make a plan to find different services. Whose responsibility is it to find those other services that you speak of? Is it the facilities? Is it the individuals? Is it a family?
Yeah, I would say that's a combined responsibility. So it depends if you're issuing, if you're going the termination route, you've had a pre-termination meeting, you're telling them why you can't meet their services. You're going to talk about what does that look like, right? Who's responsible? Maybe a case manager and the facility are going to identify services in the area that can meet your needs, but ultimately the resident's going to have to agree. I don't want to work with that agency, or I would work with that agency. Family members or support persons that the resident has identified might have some opinions about that. Maybe the resident doesn't have the physical ability to go out and tour because there are some limitations, but maybe a family member could go tour for them, or maybe a facility or the case manager could get them some pictures, or do a virtual walkthrough on a computer of what they'd be looking at if they were going to another location, or what kinds of services an agency might come in and provide. So it really is a collaborative effort. There are some requirements under the statute for what a facility is responsible for. And then similarly, if you're a recipient of services through the Department of Human Services under Medicaid waivers, there are responsibilities that case managers would have as well.
Thanks. This was a really fruitful area. And as I mentioned at the beginning of this question, I think this is going to be a huge part of a lot of appeals that we will see. And so it's worth spending that time. I did put a link to the coordinated moves statute right there in the chat based on that last question we just had, and we can talk a little bit more about those requirements. But I think, Maisie, your comment that it's a mixed responsibility, depending on where you are at in the process, is accurate, although the facility does have, if they're doing the discharge, does have a requirement to identify an appropriate setting, which includes services, could include services. So let's move on. We are still doing great on time. We have an hour left, and I know we have a lot more questions as well. I would like to fast forward a little bit and talk about, let's go to the appeals part. So you had the pre-termination meeting, you got the notice, it had the reason for discharge, and for all sorts of reasons, for all these complexities that we've just talked about, there's no resolution, and so the appeal is imminent. I want to, as I do this, I want to bring back up the timeline of the appeal, just so you can see kind of the timeline that we're working on. But Betsy, I wanted to turn it over to you, and just get you're going to get a call from somebody and say, hey, this appeal is coming up or my deadline to appeal is in 2 days, I think. Should I appeal? I'm not sure I'm going to win. Why would I even go? And how can you help me? Also, an appeal sounds really scary, and they say that there's this like administrative law judge. And walk me through the process. What would you counsel someone who is really scared about this next process, feels like the facility has been pretty clear and they even have an attorney involved now? And so how are you going to walk someone through that type of phone call?
Yeah, thanks, Sean. So definitely recognizing the stress of the situation, with that empathetic listening, recognizing where they're at, what are their end goals, and identifying that this appeal process is there to help them understand what's going on, slow down the process, and make sure their point of view and concern for their loved one is fully vetted out to know what's the best course of action. So we would direct them absolutely to continue with the appeal process. Don't be, hesitant to buy more time is basically how I would probably phrase that, of like, this is your opportunity to have the conversation again and to bring forward documentation and to direct these callers to supports with legal services that are available. So connecting them with an attorney who could represent them in the appeals process, but to not forego that opportunity to move forward, continue to have the conversation, to continue the dialogue to the nth degree, right? And just keep on buying that time and assure them that there's a lot of space for that creative problem solving that can happen. So that would probably be the approach through our helpline. And then it's based on their proximity, based on attorney and legal services available, helping them connect to resources and support. Talking about even going off on kind of some of the tangents that occur with these phone calls of what does fiduciary restructuring look like? What does support for this primary resident look like? What other concerns are at play here with family dynamics? So sometimes there's more involved than simply just a one-time conversation too. So we welcome that, and we're open to that kind of counsel and consideration as we pursue these resolutions.
Sean, we can't hear you. Oh, we can't hear you, Sean.
I will take the opportunity to pop in. One of my thoughts was we really do encourage people with, especially that provision to place cameras in residential settings. Documentation is really key in some of these conversations so that it's one more level of really clear communication. So documenting when occurrences of safety concerns happen, what the responses were, if there's that through the whole process, through the appeals process, also when conversations were happening, who was a part of those conversations. That documentation is really helpful and helps clear the very muddy water of some of this situation too.
Thanks, Betsy. There's another question about, there's been a couple of them around, whose responsibility is it? We talked about just finding, increased services. Let's say there is a discharge that goes through and the resident needs to move. As part of that move, is the facility always responsible in sort of that coordinated move plan to find a new place for the resident to live?
So Amanda, I can speak to that, and I think
Great.
Aisha might have some thoughts. She put a good resource in the chat. So if you look at the rules, there is a response. I mean, the facility essentially has to do a kind of a written assessment. So they have to do what's called a resident relocation evaluation and a resident relocation plan. And that's going to identify, the date and time the resident will move, the contact information for the receiving facility, how the resident's personal property will be transferred, how will the facility care for and store the belongings. And prior to that on the evaluation, what is their current service plan? What are their needs? What kinds of meals do they eat? What kinds of transfer services do they need? What kinds of incontinence services do they need? Whatever, caveats are on that plan. So really, yes, the facility does have a significant amount of responsibility in that regard to be assessing that before a termination occurs, and then during that process to ensure, when they leave, I mean, how's the transportation gonna occur? How are they gonna get there? Where are they gonna go? That kind of stuff. So, and there is a good resource that I know Aisha put in the chat.
That's great. That's helpful. I assume you can hear me now.
We can hear you now.
Sorry, quick microphone issues. Had to switch to the backup. So you also saw the timeline of the appeal there. I want to just spend a little bit more time on the actual format of an appeal and kind of what to expect. And anyone can answer this. But what do you tell someone who's like, I don't want to go in front of an ALJ? They have an attorney. Or if I'm going, like, what do I need to know? Where is it? What are the general rules? What can I say? What should I be doing to prepare for this? How long is it going to be? Do I have to drive a long ways? So just some of those real quick kind of basic information. What would you tell someone, encouraging them to go through with the appeal in terms of what to expect in the actual day of and what it looks like? Anyone can take this one.
I feel like Betsy gave a really good answer before. Don't forego your appeal rights. I think really encouraging people, you can, if transportation is an issue, it could be a video hearing. They're really informal hearings. If you're uncomfortable having a support person with you, having an advocate with you, perhaps you seek legal assistance and have an attorney with you, or both. Maybe you have an advocate and an attorney, or a family member and an advocate, or all three. So just really reassuring them it's an informal process. They're going to have an opportunity to tell their story, to bring documents, to bring evidence, whether that's in the form of electronic monitoring evidence, whether that's the form of their service plan or their assisted living contract, and really have an opportunity to tell their story and why they feel that they should be able to stay where they are. So I think Betsy might have some other things to say, and maybe Aisha as well, but I'm just piggybacking off her already great answer on that.
I think that's really helpful. And just to note that the ALJ might be asking questions themselves and trying to tease out the actual story, and is really trying to get at trying to make the best decision possible. So there shouldn't be kind of an overarching fear in doing that and telling the story. Although, you know, if you do have an attorney, you might have an advantage in terms of no, especially if the other side has an attorney, in terms of knowing some of the tactics and the general rules and some of the arguments that might help the ALJ ultimately make a legal decision as well. Because there's facts that need to be teased out, but there's also law. And so I think, yeah, both of you, that's really helpful. And frankly, we don't fully know what OAH hearings will look like well into the future, right? And so all of those issues around how it's actually conducted, it may be like this, frankly, for a long time to come. And nursing home discharges oftentimes happen in the nursing home. The same could be true for the assisted living setting as well. So I'm glad that people are going to be hearing that message, because it's important to enforce all these rights, that people aren't afraid to actually go forward with an appeal.
Well, and I think, Sean, one more thing I was just thinking is, you know, if you pursue that appeal route, and you know, you get a hearing scheduled and it's out 14 days, that doesn't mean that in between time you can't come to some sort of a compromise with the facility for continued stay and cancel that hearing, right? You would have every right to say, hey, wait, you know what? We came up with a resolution and we don't need you anymore. And so I think that's another important piece. You know, on the SNF side, we've been doing this for years. So, and I shouldn't have abbreviated, but on the skilled nursing facility side, we've been doing this for years. And so, you know, just because you request a hearing and just because you kind of evoke your right to do that doesn't mean you have to follow through. If there's a compromise, which we're always searching and seeking, that can be canceled, and you know, they wouldn't have to go through with it as well.
And during that time frame, if they need to have just support, just to talk through, I'm having second guesses, I don't know how I feel about this, you know, those emotions can fluctuate day to day. And so that's why we're here to provide that support too, and be like, who do you lean on for these times of stress, and how are you taking care of yourself so you can prepare for presenting your story in the best light, so that you can empower yourself to have some really great solutions available to yourself. We are happy to do that on a repeated basis if needed sometimes.
Any others, Amanda, on appeals? Otherwise, I'm going to move forward.
Yeah, I'm going to let you move forward. I'm just going to state ALJ, administrative law judge. We've been abbreviating, but had a question. So just to clarify.
Yes. Yeah. And we actually, we've done a little bit of the jargon. I am guilty of it as well. I think we've covered them all. Maisie, let's go back real quick though, because I know we'll have this question. You've mentioned the UDOLSA, I think, a couple of times. And I think I know what it is, but can you just spell that out? I think it's the uniform checklist, but you are deep in the weeds on this, and it's really, I'm so glad you're here, but tell us what that is and how you've been using that.
Yeah, and let me just double check. I want to make sure, you know, UDOLSA is really the last way we referred to it. It's actually the uniform, I believe it's now referred to as a uniform disclosure checklist. So I know some of the folks in the attendance box here knew what I was talking about, but so we're talking about the uniform disclosure checklist, which is basically thank you, Shelley, in the chat, uniform disclosure of assisted living services and amenities. This is basically the document that the assisted living was required to file at the time of their application, and anytime they're changing their list of services or amenities, they would be required to provide a new checklist to the Minnesota Department of Health. And this is going to say, do you offer 2 to assist? Do you offer med management? Do you have a pool? Do you offer exercise classes? Do you have RNs on, you know, to provide ventilator services, or whatever the case may be? Do you offer distribution of medical cannabis? I mean, there's all sorts of areas where, you know, meals, services, medications, and there's sections. So this is really going to be an important document for both a facility and a resident and any advocate to look at when we're dealing with any kind of termination issue, because this document delineates, you know, what you promised to provide, right? If you're the facility, you've said, hey, I promised that we were going to offer these services. We then compare that to the assisted living contract and what the person signed and agreed to when they moved in. And so if there are changes to that because you've changed operations or you've made some sort of a modification, you need to update that. You need to make sure the resident gets a new copy of that. You need to update the assisted living contract accordingly. So thanks for that clarification. And yes, I was using old language.
Great. So let's move forward. And if we stumble on any other jargon, please type it in the chat, and we'll try to circle back and get that. I do think it's important. Again, a lot of these terms are going to be new for us. And speaking of new, let's go back to the coordinated moves. I know we've talked about it a bit, introduced it at the beginning, and we talked about it a little bit, especially in the context of trying to resolve a case, you know, even without a hearing, and what are the responsibilities. But I want to make sure we really hit this part of the statute because it is an important requirement that a facility follow, and ultimately it may be the best way to resolve this is with a very comprehensive coordinated move. So let's just kind of go back and refresh some of the basics. Aisha, you've already given a good resource about kind of what needs to happen with that discharge plan. But I want to drill down a little bit deeper about this finding of a safe place and the setting up of services. And let's also talk about it in terms of an appeal, because I think this is important. So let's say you are advising an individual who is heading to an appeal. It's a couple days away, and they said you ask them about the coordinated move. Well, give me the discharge, you know, plan so I can see what the facility's saying you have to go, and there is none. Or there's a discharge plan that is, you know, leaves you wanting, or the safe place that's been identified is I said ultimately I want to move home, so I'm going back home, but there's no services set up at all. So where would you enter in? Maisie, I'll turn back to you, and Betsy, please add in as well. What would you start to advise that resident to start asking, knowing what the facility's obligations are under the statute with a coordinated move, even before the appeal hearing?
Yeah, I think, I mean, it kind of depends in terms of the advocacy relationship. So sometimes residents are really comfortable calling a facility and asking questions, and sometimes they will defer to their advocate to do that, you know, maybe our office, maybe an attorney. So I think just following up to ensure, you know, where is that assessment, that resident relocation evaluation? Have they done a resident relocation plan or evaluation and not given the resident a copy? We've seen examples of where, you know, a facility prior to the new law would say, well, you know, we told them they were going to have to leave by whatever date, but no, we didn't give them a notice in writing. So just kind of going through the checkbox of, did you do these things? I guess, you know, it's kind of an advocacy decision if you do that prior to the hearing, or, you know, I mean, my goal is always to resolve a hearing, right? So I don't want to go to a hearing. I don't want to waste everybody's time and energy, especially if I'm really confident that the resident's going to prevail. So I might encourage in that situation, hey, if they really didn't do these things, if you're comfortable, let's have a quick call with them to say, hey, we're going to point out in 2 days at this hearing that these boxes didn't get checked, right? They didn't do the assessment. They didn't do a resident relocation plan. They don't have a safe and appropriate discharge location, or whatever those components are. And perhaps the facility will say, oh, whoa, wait, we don't want to go to a hearing and lose, right? And so they might pull back and say, wait, you know what, we're going to rescind the discharge. We're going to talk to our attorneys. We're going to rethink this. And other times, you know, maybe it makes more sense to wait until the hearing, or maybe the resident wants to wait until the hearing. If there's an attorney involved, certainly if you're an advocate, a family member, a resident, you can communicate with that person and find out kind of, you know, or maybe even point out, hey, this is really concerning to me. They didn't do any of these things, and we're about to have a hearing in 48 hours. And the attorney might say to the facility, whoa, we need to really rethink this. And I guess I would just caution residents in those cases, just because they rescind a discharge notice because they feel like they're going to lose, doesn't mean that they might not issue a new one later, right? If the issue hasn't resolved, the transfer, specialty diet, need for additional care and services, it's possible that they could rescind a notice, forego the hearing, and maybe 5 days down the road or 15 days down the road or 30 days down the road, they give a new notice. So I think just preparing the resident for the possibility that just because they maybe agreed to forego it now doesn't mean it won't come back later, and to be prepared. So if it's a non-payment case, really encouraging them, it'll be important to pay your bill between now and then. Or if it's an issue of, they're alleging, unsafe behaviors on behalf of the resident, they've lashed out at a staff or swore or thrown things or whatever, kind of having that conversation about, if you need services to learn how to manage your behaviors better, or if you need a consultation with your doctor about medications that help you do that, getting those things in order and really trying to continue to resolve the concern if it's something that you are willing to acknowledge that you might need assistance with. But I think, really peeling back those layers, did they do these things, and then deciding based on your advocacy at what point you point that out. I think avoiding the hearing and being transparent is the best route. As advocates, the Office of Ombudsman for Long-Term Care is always going to take direction from the resident. So if they don't want that phone call made or don't give consent for that phone call to be made ahead of the hearing, we wouldn't do that.
And how about Betsy, anything to add on that in terms of MEJC and what you would be telling that individual?
Yeah, I think that we would want to provide that space too to talk about end goals for the resident. What do they really want to see happen? How comfortable are they at this place of residency? And if we're looking at that coordinated move piece, it's so helpful to identify who's taking up what responsibilities. And oftentimes it's making sure that they're in touch, especially with waivered services, that they're in touch with the case manager, that they've, looked around for, are there different facilities that would provide cares at a different level that you'd be more comfortable with, or that you'd see, planning long-term a little bit, seeing if decline is going to be inevitable, what more would you like to be receiving, or how would we like to resolve these conflicts now? And we have the conversation oftentimes of like, those wait lists are long and it's good to get your name on them. And working with case managers to make sure they're part of that communication also, because there's a lot of behind the scenes work that does happen, but knowing who's responsible for which piece, and that the resident, we do have that conversation of getting the resident to recognize, like, here's the realities that can play out. And you get to steer some of this, but you need to be willing to recognize your own behavior, or willing to recognize what services are priority looking forward, so that we can come to those conversations to try to resolve things, like you're saying, Maisie, before the hearing even happens.
Couple questions are on this. So
Great.
Here's a direct one that I don't know if it has a direct answer, but in cases where the facility issues a discharge, who is responsible to find another facility for the resident?
I can answer that. So there's a couple things that are relevant here in the statute and the rule. I mean, in the ideal situation, it would really be the staff and the resident working together. If the resident identifies a place, there are a couple provisions in the statute that are explicit that a resident can choose where they want to go. So that's important. If a resident has decided something and a facility thinks that there might be a somewhat better option, ultimately the resident is able to make that choice. Now, if the resident is choosing something that the facility thinks is a danger, there's always the ability to file a MARC, adult protection report. However, the resident is able to make that choice, or their decision maker, should they have a guardian or something of that nature. If a resident has not identified a place that they are wanting to move, that is the obligation of the facility to find a place, because the facility does need to comply with the coordinated move requirements that Sean pasted into the chat, as well as those requirements under the rule. And that includes identifying a safe and appropriate location, identifying an appropriate service provider. And if that is not done, then the termination cannot be carried out. And those safe landing requirements are applicable not only in the termination context, but in a variety of other contexts under the statute as well.
How is that? Can you talk about any differences if the resident chooses to end their contract voluntarily and moves out? Does the relocation plan requirement still apply?
So that depends. In most circumstances, these statutory and rule provisions that are in the chat would not apply. If it's a situation where the facility has made no actions toward asking someone to move, and someone comes and says, hey, here's my 30-day notice. Again, there may be obligations on the facility to make adult protection reports in certain circumstances or things of that nature, but these specific statutory provisions that we're talking about would not apply in that circumstance. However, under the rules, it does talk about a situation where there may be a pre-termination meeting that's initiated by the facility. And then the resident at that meeting may say, okay, I'm gone, I'm out of here. I'm gonna sign something, or I'm gonna tell you I don't want to appeal, I don't want to be here anymore. The rules do say that in those circumstances, coordinated move requirements apply, as well as the protections that I put in the chat under the rules that are related to moves. So the facility will still have to work with that resident to find a safe and appropriate location and service provider.
So Amanda, if you don't have another one, I have one more quick follow-up with Aisha. I think it's important to reiterate, we've spent most of our time talking about at the discharge process and discharges themselves. But Aisha, you just alluded to the fact that there are other circumstances where the facility still has to do a coordinated move. So explain that a little bit more. What do you mean? What are you talking about when you say what are those other circumstances? Oh, hit your mute button real quick.
Sorry about that. So I actually happen to have a little list of what I think it is. I may be missing something, but the coordinated move requirements apply if there's a termination of housing or services, which is what we've been talking about. If a facility is not renewing a lease, if a facility is reducing a resident's service to the extent the resident has to move, if the facility's license is restricted by the commissioner such that the resident has to move, if the facility is closing or relinquishing its dementia care license, and also the situation that I just talked about, which would be if a resident decides that they want to move and not to pursue an appeal at the time of that pre-termination meeting.
I think it's just helpful as a reminder that there are a lot of other circumstances where someone might have to leave that might not be a termination, but these protections still apply. They're really envisioned as a protection, and that also gets back to kind of the requirements of the facility because it's a protection for the resident. Amanda, I had one more kind of pre-planned question or topic, and then I know we've been filtering in a lot of questions, but I know we have some others that have already been sent in, so we can turn to those right after this if that's okay. So a final thought in this kind of world that we're talking about of other situations that may arise that are not strictly a legal termination. And specifically, I want to talk just a little bit about a non-renewal and what that is and what the statute and rules say about that. So just real quickly, a non-renewal meaning the provider comes to the resident and says, your contract is up in a certain amount of time, and just know that we will not be renewing your contract next time. So we're not renewing your contract. So you either can't live here, or we're not going to give you services anymore, or we're not going to give you services. And so that ultimately means you probably can't stay here if you don't bring in your own. So that kind of typical situation. So I'll open it up to anyone to talk a little bit about the non-renewal and anything that we haven't already said, either about coordinated moves or other protections that exist, because this does happen. And the statute does not require the full termination process to go into play, but there are some protections that exist. So I'm sure people are interested in generally what those are.
So the requirements of non-renewal, there's a specific statutory section dedicated to this, and what it outlines is that there's shorter notice periods if you're doing a termination. So for a notice of non-renewal of housing, there's a 60-day notice that's required for that. The notice has to include the reason for the non-renewal and the contact information of the Office of Ombudsman for Long-Term Care. The notice needs to be given to the resident. It also needs to be given to the case manager if there is one, and it needs to be sent to the Office of Ombudsman for Long-Term Care. And I will put in a little plug that there are a variety of notices under the statute that need to be sent to our office. And one of the things I know MEJC has kindly offered to do after this webinar is to include in what they send out, and it was also in Sean's PowerPoint, the link to our notice cover sheet, which outlines all the different notices that need to be coming to our office. It has cross references to the statute and rules sections to make it easier for folks to figure out what they need to be sending us and what that information should include. When that non-renewal takes place, there is still the coordinated move requirements, as we mentioned before. So there needs to be the determination of, okay, if this resident is leaving, they need to have a safe housing provider. They need to have a safe service provider if services are still needed and desired by the resident, and making sure that that process does go smoothly and ensures that the resident will have a safe place to go.
Anything else before we jump into questions about non-renewals? All right, Amanda, I see that we have some more Q&As, and I know that there were some questions sent in ahead of time as well. So I'll turn it back over to you to facilitate, and I will chime in as well if needed.
Sure, a couple, just some that we haven't gotten to yet. And so I'll just throw them out for you all to answer. We haven't really talked about fees. So for the discharge planning, I'm presuming that's what this question is getting at. How does the ability to pay the fee, I assume they mean assisted living fees or fees that may come with a required move, fit in? What if someone needs to leave a current facility but may not have other options financially?
If this question is getting at the issue of who has to pay for services, it would be the resident that would need to be paying for services or additional services that are needed prior to the move. If there are financial barriers to the resident moving, there is still that obligation on the facility to ensure a safe move. And as Sean mentioned earlier, that cannot be to a homeless shelter. There does need to be another place that is found for the resident to go within whatever the financial constraints are of that resident.
Well, it's really, okay, so the question is really around discharge planning. You can't release them to the street or to a shelter. So if there's no ability to pay, who pays for that?
So I would just, yeah, I would ask for some further clarification. I mean, the infrastructure of the license would warrant that you have, you know, a director of nursing who's governing what care needs people have, that you have a housing manager, an assisted living director rather. So, I mean, I guess I'm unclear about what the actions that would have a dollar amount attached would be, like making phone calls or.
What happens if somebody's going to be terminated for, say, and I don't know if it's non-payment, there is no more money, that person has no more money to pay. And you cannot release them to a homeless shelter and they are in a certain,
Well, I mean,
somewhere.
so yeah, if I mean, I think this might be one that's better answered offline, and I would offer my phone number in the chat for people
Well, I
to
mean,
call.
I think that there's probably lots of cases where, you know, I mean, we get those calls, you do too, where there's just past due
Yeah.
bills, right? And
Yeah.
but there is no more. The next place is going to require
Yep.
funding as well.
So,
Where do they go?
yeah, so
How do they?
I think if it's a non-payment issue, I mean, the first thing to assess is if they were paying privately and now they've exhausted their funds, helping that person to apply for any public benefits that they might be eligible for, you know, helping them to fill out the application, helping them to letting them use your fax machine or your email or your, you know, helping intercept their mail with their permission to get the proofs needed to get, you know, approved. The challenge with, you know, if there's a gap in between when the private pay ended and the you know, benefits would start, you know, there's no retroactive payment to an assisted living like there is on the skilled nursing side, right? So Medicaid will go back 90 days if you're living in a skilled nursing facility, and that is not the same for waiver payments. And so, you know, the question that I ask facilities, let's say you have 3 months of non-payment, right? You have 3 months, nobody paid for services, nobody paid for rent. You help this person to get Medicaid in place. They now are open to the waiver effective, you know, 3 months later. Discharging them doesn't get you paid. So, you know, is there, and that's not going to get you any money. So is there a benefit to discharging them if now they have a payer source and now they're going to be current moving forward? That would be something that we could kind of talk about in terms of advocacy, and something that actually happens a lot. I would say getting ahead of that, having good admission policies, having conversations with people as they come in the door about, you know, what is your financial situation? Do they accept waivers? Do they accept private pay? At what point, if they accept waivers or don't accept waivers, would they be able to assist them with some social services to get them approved, arrange for another setting if they don't accept that payer type, et cetera? So those are really, you know, getting on the front end of that on the preventative side is really important, and having those conversations. And nobody likes to talk about money, but at the end of the day, a provider does need to be paid for the services that they give to people, and paid rent, right? Those are two separate things. So I think if that's what it's regarding, that would be my, I'm sorry, I was misunderstanding that. But yeah, as far as the, you know, I guess I was interpreting it related to a discharge plan, what fees would be attached. So.
And I can speak to Maisie's comment about getting it ahead on the front end, because we have had calls from facilities with good intentions of wanting resolution for an unpaid bill, but it's an indication of financial exploitation that's happening with a POA who's supposed to be paying these bills and they're not. And there's deeper stuff going on financially with this estate. And so that has been an indicator that more intervention is needed on some of these cases. And the facility is doing really great work saying, there's a problem here and we're going to have to pursue resolution eventually, but we think we can identify there's something going on that needs some care before we would have to intervene at all. So there are reasons to have these money conversations early on too, and say, what is the strategy moving forward to make sure this person is cared for?
What about the cost of physically moving someone? So a U-Haul, or the cost of like getting person from this facility to the next one when there's no family or support system to do that. Who bears that cost?
So
Aisha, do you want to answer them?
I'll take the first shot and then open it up. So the statute is silent on that. There is not a moving truck provision. The discharge plan needs to be detailed and needs to kind of give some of those general details, but it doesn't require that cost burden to be put on the facility. Oftentimes, there are a lot of Medicaid services. There are potential Medicaid services, especially under the waivers, which is the the tool that a lot of folks who cannot private pay use to stay in assisted living, that can also be used for relocation costs. So especially those case managers on the call, this is when you get involved and can get involved if you're working with someone on a waiver or other Medicaid services, because there should be some relocation funds available for things like that. But ultimately, the cost wouldn't fall to the facility that's doing the termination. Other thoughts, Maisie?
Yeah, no, that's great. I'm thinking, there are some communities, I would say rural Minnesota specifically, where there are other avenues that you can look to. I'm not as familiar with some of the metro services, but there are tie-ins to, let's say, the mental health fund if someone has an underlying serious and persistent mental illness, or there might be a local agency or a church, or some other community organization who does volunteer services, a senior citizen organization that does that kind of stuff. So I've seen some pretty creative options in that regard. I think I saw a case manager once beg her supervisor for permission to load up the back of her van and help someone move, which I don't know is a great resolution, but bless her heart. So it does get difficult sometimes, but I think, the responsibility of the provider is just ensuring they're reaching out to the right organizations, the case manager, and trying to pull those services together. So if a person does have to go, that they're not going without their things.
And Maisie, you brought up rural Minnesota, and so I want to talk about rural towns or frankly small facilities in geographically isolated places. The question is, we're struggling to find staff already, and how do they proceed in meeting their obligations with this, given the other constraints that they might have, either geographically or by size?
Yeah, staffing is so hard right now everywhere. And I think I did see that question, and I'm not sure if it's specific to just, meeting new needs if needs arise for, more caregiving, or if it's related to, having alternative providers even in the area that can meet the needs of people. And I think those are, again, going to be really individual types of situations. I know, I strongly feel that there needs to be some economic reform in this regard. We don't have the infrastructure in place to pay caregivers enough to get them to come and do this really hard work. But we can't fix that today. And I know you can't fix that at your facility tomorrow. And so I think being realistic on the front end, right? About like right now today, what does your disclosure checklist say you can do, and making sure you're fulfilling those obligations. And beyond that, being clear with people about what are your limitations, if there are limitations, so that people do have a realistic expectation. Because if you live in this small community and the person, it's really important to that person to be able to age in place, right? And not have to move. Maybe on the front end, they make that decision to live 30 minutes away to a place that they could maybe has a secured memory care unit if they've had, a dementia diagnosis and foresee a future of needing that, or, have a continuum of care community where they offer a plethora of services all the way through to skilled nursing. So I think, again, just having really open conversations with people on the front end. I empathize on the staffing piece. I know that's so very hard. There are some avenues like through the waiver, and it's off topic here today, but there's some ability to do some like telehealth management, and to be able to use tools through electronic means of monitoring people's conditions and doing things like that. So that might be something, if your area has good broadband, that you could be talking with the local public health entity or case managers about. I know there are some provisions under the waiver for certain things that can be paid for in that regard. So maybe you are paying an on-call staff to be monitoring something, or that's kind of more individualized to a person. But there are some technology tools that could possibly be tapped into. But I don't have a good answer on the staffing today. I know it's very difficult.
What if a provider gave discharge notice prior to the AL licensure going into place on August 1st? Are they required to issue another discharge notice following the licensure, or do they have to follow different rules?
You want to take this one, Asia?
I thought
we were all going to chime in. Go ahead.
Well, I would certainly think it would be smart to issue a new one. I mean, we're at the end of September at this point, and the licensure has been in effect for 2 months. So my take on it, and I'm curious what Sean thinks, but my take on it would be that a new termination notice would need to be issued at this time.
Yeah, I was gonna say the same thing, and not that we're giving legal advice here, but I think just a fair understanding of the statute is the statute lays out the requirements for licensure. Once you are licensed, you need to follow those requirements, and those requirements have the pre-termination notice and then the notice. And my guess is, I mean, in this, there was no such thing as pre-termination. So just for that alone, I think the process would need to be start over. And wouldn't go, but I wouldn't go much further in that. There may be complications too about when the facility is actually licensed and things like that. So we won't get into those specifics, but I think that's a fair reading.
Someone has a question about if the My Move Plan DHS form is required, and if so, who completes it?
So Betsy,
Dawn?
you may have seen these, or Maisie, you have. I know that. So DHS, Department of Human Services, and I know we got a question in before the webinar too, a little bit about payment on Medicaid. So I'll just quick answer these quick hitters. So DHS is not the regulatory authority for the assisted living licensure. That's MDH, the health department is. And the health department does not have a My Move plan or any like that is not required. The requirements for the discharge coordinated move is all right there in the statute. So that would be where we would direct you to appropriately follow the law. The My Move plan comes from DHS, and I think is most likely related to some of those supports I was talking about earlier under our various Medicaid waivers, disability waivers, elderly waiver, and even other programs. DHS helps people move out of more institutional settings and into more community-based settings, into their own home, into a place where they can receive supports to stay out of nursing homes, other institutions. And the My Move plan is really, I believe, connected to that. So the short answer is ultimately no, refer to the health department and to this statute for those requirements. And then while I'm on it real quick, there was a question we received about Medicaid and can Medicaid pay for assisted living, the new assisted living service? And the answer is yes. The way and it's not much different than in the old housing with services system. The way in which someone who is on Medicaid would do that is you would qualify for a waiver that we've referred to a couple of times now, either an elderly waiver or one of the disability waivers. Sometimes you've heard of the term CADI waiver. And under that waiver, there's a service called customized living. And that's what pays the facility to offer services. And then there's another subsidy provided by the state that pays for the housing. And that is actually not too much different at all than what we had under housing with services. So that whole system still exists. And when we've been talking about case managers getting involved, usually we're talking about people who are on a waiver because a requirement of being on a waiver is that you have a case manager. So Amanda, I did a little 2-for-1 there, but did that cover it? I know Maisie might want to have added something.
Yeah, I would just say I believe the My Move plan would be related if you're serving someone on a disability waiver, and you may or may not be in your setting. So what I would defer to on that is the case manager. So if you have someone that's living in your setting and you're looking at these termination rule, there's nothing under the assisted living statute or rule, but under the HSBC waiver, piece, they may ask for that if you're serving someone. I believe it's specific to disability waivers.
And there's an important caveat that Toby Pearson put in the chat that Medicaid, reminding Medicaid only pays for the services, not for the housing part of assisted living. So not all people on elderly waiver will qualify for the GRH.
Correct.
Which is now referred to as housing support. So not GRH anymore. And the housing support people will tell you that.
Just to dive deeper into our alphabet soup, but it is an important caveat. when you're working with anyone who's trying to qualify for the waiver, make sure that they can qualify for both subsidies that will allow them to live somewhere.
If a couple more questions I think we can get to, if a resident plans to move, what happens if the facility doesn't have an opening? So they have a place they want to go to, they can get in, but they can't get in now. How long can the resident remain at the current place where they're being discharged from? If they have a place to go, but they need to wait longer.
I would say that depends on the facility's willingness to kind of work with them. You know, if we've gotten to the point where a pre-termination meeting maybe resolve the issue and you've decided, hey, they've identified this facility that can meet their needs, but the facility can't tell you when they'll have an opening, right? It could be 30 days, it could be a year. You know, are they willing to go somewhere else in the meantime? Is the facility willing to provide those care and services with, you know, some support systems in place for a period of time? Are they even willing, you know, we talked about compromises a lot. So if you had a pre-termination meeting and you said, hey, we'll do this for 30 more days and then let's have another meeting and maybe revisit it. So I think that's just going to depend on the facility and their capacity to meet that person's needs, or, you know, the needs being able to be met by an outside entity if that was the agreement, and for how long that's sustainable. But that's a common thing that we actually see where, you know, a facility and a resident really do agree, hey, this isn't necessarily the best place to meet your needs long term, but we'll eke it out a little here, and we put these little pieces in place to make sure that we can meet your needs. And sometimes that's tenable for 30 days or 60 days, but it's maybe not for a year. And so having, you know, there's 26 letters in the alphabet, so having an A and a B and a C sometimes might be the point at which you land, is that you're going to have different plans depending on circumstances.
Great. Sean, Aisha, I don't know which one of you, I think one of you probably want to take this one. Some acceptable reasons for non-renewals, and can a non-renewal be appealed?
Go ahead, Aisha, you start and I'll fill in.
Sure. The assisted living law does not outline specific reasons why non-renewal can occur. However, those reasons must be legal. So if, for example, a facility was non-renewing and that non-renewal was a violation of fair housing laws, for example, then there's still an opportunity for an advocate to request a reasonable accommodation, to bring up if there was a specific discriminatory issue based on protected class, to bring up that shouldn't happen and here's why. But as long as there isn't another law that would come into play to say that this decision is illegal, discriminatory, retaliatory, whatever that may be, then there are not constraints on the specific reason for non-renewal. In terms of whether there is an appeal, no, there is not an appeal the way that there is for a termination. So my suggestion is, if someone receives a notice of non-renewal, is to reach out to our office, reach out to MEJC or another advocate, and find out about your rights, talk about what the reason is that has been listed for the non-renewal, and dive into that a little bit, and then take it from there.
You covered it well. You also covered another question that we received before the webinar, and that is, do other laws apply in this space? And we spent a little bit of time in the presentation giving you the actual statutory sites, both for the statute and the rules. That's the bulk of the law that applies, but Aisha just pointed out a couple of other really important ones, and that includes federal and state fair housing laws that govern protections for protected classes, whether it's race or disability. And so that would be another key area to also keep in mind that is in play here, that we didn't spend much time today on specifically.
I just want to take a couple concluding points that I want to make sure that everybody knows about. We are planning to host a similar session to this one in mid-November, so you can look for that in our emails. But we'll do this again as we kind of continue through the process of the new assisted living licensure structure, and we look to sort of protections around rights and appeals. The other thing that I'm going to point out to look for is the Minnesota Elder Justice Center is in sort of the final stages of creating a manual aimed at really helping people walk through, particularly residents or advocates and attorneys who are helping a resident walk through a discharge and appeal process. And so this manual will be released. We'll have it ready mid-October, hopefully. So you'll get information about that in an email from us if you're on our email list. But that we're hoping that will be helpful as people are looking at the discharge and appeals process through the new assisted living licensure structure. And that project is also funded by the Board on Aging. And I want to thank our partners from the Ombudsman Office for Long-Term. I accidentally muted myself. So thank our partners from the Minnesota Office of Ombudsman for Long-Term Care, OOLTC, for being here today. Thank Sean, thank Betsy from our staff for being here. Thank all of you for sending in questions ahead of time and putting in really robust questions in the chat. We hope this was helpful. And as we are looking to plan sort of part 2 of this, please feel free to reach out to any one of us and let us know, or I guess maybe just Sean or I won't burden everyone else's inboxes, but if you have suggestions for what you'd like to see from sort of a part 2, feel free to reach out to Sean or I as we plan that. With that, anything else from any of the other panelists before we sign off, because it's 3 o'clock?
Thank you, Amanda.
Great, thank you all. We will be sending out the webinar or the slides, and there is a recording available as well of this session if you would like that. So thank you all.
Thank you.